So the next panel is discussion number 6. It's in relation to cybersecurity in data privacy in litigation. So the moderator in this one will be Ms. Betania Allo, founder and principal consultant of Betania Allo Cyber Law and Policy. And our expert panelist will be Mr. Mohammed Anum Saleem, legal director, AlDhabaan Partners Eversheds Sutherland in Saudi Arabia. And Ms. Beatriz Ruiz-Beato, Head of Global Data Privacy, NEC Corporation from Spain. Give them a warm welcome. The PowerPoint or?
He has my whole questions. That's why I was like.
Do you know any jokes? Do you know any jokes?
No. Apologies. I'm just waiting for. He was printing the whole outline, and I don't have it yet. So, just a break. Yeah, have a coffee, but come back in like 1 minute. Okay, it's me again. How are you doing? Assalamu alaikum again. It is my pleasure to be here with Beatriz and Anum. Thank you so much. I'm really sorry about the delay, but I'm very excited for this amazing conversation. It is so important, I think, to talk about cybersecurity and data privacy in the context of law, compliance, litigation challenges. I would like to ask to start, by a small introduction. I think if you can start, Beatriz.
Sure. Thank you so much for inviting me today, and thank you for all of you to be here. My name is Beatriz. I'm from Spain. You can notice from my Spanish accent, very strong accent. I've been dealing with privacy for so long. Yeah, let's leave it like it is. I'm the head of global privacy at NEC Corporation, which is a Japanese company. And today I'm giving you my thoughts, yeah. So I'm not representing my company, but thank you so much.
Thank you so much for coming all the way from Spain. Please.
Sorry.
Fadal.
Hi, can you guys hear me? Yeah, it's working. Okay, thank you very much to all of you once again. My name is Anum Saleem. I claim to be a technology lawyer, but in fact I've been working in technology for almost 2 decades now. I'm based in Saudi, in Riyadh. I work with Eversheds, Sutherland, and I'm very glad to be here today and to share my thoughts with you on the topics.
That's amazing. Thank you so much. I think that since we have such a small panel, we're going to make more of a conversation okay? If that sounds good for you. I think that although they both have experiences from different jurisdictions, I think they have a lot of points in common. So I'm going to start with Anum. So I'm quite familiar with the incredible transformation in Saudi Arabia. The kingdom is integrating AI in pretty much every single fiber, I would say, of its Vision 2030 strategy. I wanted to ask you what legal and regulatory frameworks are emerging to support this transformation across sectors, like, for example, healthcare, education, smart cities, logistics. I think that a lot of this can be replicated in the region and beyond. So I think this conversation is very important. Please.
Definitely. I think all of us are aware that AI is becoming or has already become a part of our lives. But I think the adoption by the governments have been sporadic, especially their pace. Saudi government institutions have taken a step forward, have taken a leap, you can say, for adoption of the AI technology. Almost 71% of the government institutions have already integrated it in some form of the other. As Betania just mentioned, in terms of the impact could be seen stronger in healthcare, in education, in logistics. But people who are living there, we can feel it in every facet of life. And I think it was certainly turbocharged with the advent of COVID. So obviously there was a need at that time for everybody, not only the private sector, but for the public sector to evolve as well. But Saudi has not stopped ever since. So since 2020, they have taken a lot of initiatives. They have taken they have made a lot of investments, and that is all reflected in the global rankings that they have had, as well. They are now on the UN AI advisory board. There are so many statistics that I can share with you for Saudi, but perhaps that will become a little too pedantic. But I think it is, again, in terms of effects, as I said, that we are seeing when we are living in Saudi. And also one more thing that I would like to say, that I have seen a policy, especially from the private sector, to expect very fast or rapid results once they adopt any AI technology. They don't realize that they have to be in this game for a long time. The effects are going to come maybe a little late, and they have to stick with it. But a common mistake that we have seen, especially with the private sector, so to speak, because they do not have that much financial strength to bear it for a long time, that they are looking for short fixes. AI, in my view, is not for short fixes. It should be counted, or it should be a long-term strategy for any organization or a government.
That's incredible. I think it's so admirable, everything that's happening, and not only from the political decision, but the skill set that you see in Saudi Arabia towards these ambitious projects is incredible. So thank you so much for this. It's really fascinating. Beatriz, building from that, your global vantage point, how do you see as the key sector border challenges when it comes to privacy litigation today?
Well, I wanted to start saying that, of course, in recent years, we have seen that, the increasing number of cyber attacks wherever you are, right? But having in mind what happened yesterday, so I'm Spanish, so I'm going to criticize what happened yesterday, right?
Please do.
So there is a huge assumption that it was a cyber attack, right? It has huge, fully impact on critical infrastructure in 2 countries in South Europe, right? No telecommunications, no transport, no electricity, no water. So 2 countries were collapsed at least for 12 hours, and
Spain and Portugal.
yeah, Spain and Portugal, right? And well, there are a lot of rumors that there were certain locations around Europe that it has also impact, yeah, but very localized. So, from a government point of view, do you really think that the Spanish government were prepared for that, assuming that it was a huge cyber attack? I don't think so, right? So that's a clear example that cybersecurity and data privacy, yeah, are not only technical issues, and it doesn't matter if we are talking about the government. I'm more familiar with for a corporate or a multinational point of view, but I think that we need to start thinking, yeah, that those 2 areas are not isolated areas. They are common, right? And companies need to start thinking on having business strategies, prioritize that, right? And to start having a robust privacy and cybersecurity frameworks in order to avoid these kind of situations that happened to 2 countries in Europe yesterday. What are the trends, yeah, that I have seen from a global point of view? Of course, security and data breaches. This is a huge trend. We have seen more and more cases related to lawsuits, individuals claiming, yeah, for their own damages, also class actions. There is a huge trend as well. And well, from a legal perspective, and to avoid these litigation issues, well, companies, we need to be much more, they need to encourage, right, to have a very strong and solid compliance frameworks. Another trend, it's related to, we have seen, yeah, the data protection laws are evolving, and it's not only the GDPR. Of course, I think that the GDPR was the starting point, but it's not the only one right now. And we have seen that the regulators are starting being more focused on enforcement activities. Of course, depends on the global scope, yeah. Some countries are more active in that sense, but that's another trend. AI, yeah. We have been starting seeing cases related to AI. The way that the AI models are collecting privacy, personal data, yeah, with no transparency, no controls, no technical measures in place, no transparency. And of course, something that it's really affecting Europe, it's the cross-borders situation. It's always there. It will be always there, yeah. And yes, I could say that this is more the data privacy trend.
Just like a follow-up question, and also building upon the colleague's question in the previous panel, is there any like surprises, differences that in these laws that can catch companies off guard, especially when it comes to the litigation strategy?
Well, as you mentioned in the panel, I think that the culture, it's also very relevant, yeah, in order to implement data privacy litigation or legal strategies, right? Just with example, right? The way we understand in Saudi sensitive personal information and the way we understand sensitive personal information, it's completely different, right? So this is one of the aspects that companies need to think about it, yeah? So we are always thinking on a global privacy framework with the same legal strategy, but at the end, yeah, yes, you can have an umbrella, but it needs to be very flexible in order to allow to comply with local and specific requirements. I think that all data protection laws around the world are coming from the same foundation, the same principles, wherever the terms are, right? That's not changing, but they have unique things. And it's completely different. I mean, the way in Saudi, under the data protection law in Saudi, understands consent, for instance, it's completely different on the way we understand consent. We are always trying to avoid the consent. And here, for instance, until we will see how the law evolves, the primary legal basis, it's always the consent.
And any comments?
No, of course, to just build up on that point, it's not only, as you've just mentioned, it's not only the consent or the definition of consent which is different in different laws, and as to how the regulators are evolving and trying to keep pace with the developments as well. So in Saudi Arabia, the PDPL, Personal Data Protection Law, it came into effect in September 2024. The implementing regulations were issued almost at that time as well. And now only after 7 or 8 months, we have seen a draft for public consultation for amendment of those implementing regulations. Now, even when the PDPL came into force, there was a bit of history to it. So they started the process in 2021. They came up with one draft of the law. They almost issued it, but just 1 day before the promulgation, or I believe 2 days before the promulgation, they postponed it by a year. Then they almost completely overhauled the draft law, the PDPL itself. And now, as I said, they have come up with amendments to the implementing regulations as well. So the regulators obviously are trying to keep pace with technology as well, and they are trying to also stay ahead of the curve. But the technology and the developments are accelerating at such a pace that it is very, very difficult to do that. And obviously, in terms of, as we have seen the incident in Europe yesterday, when you have quite a few member states, many of the times there are some local nuances also to the law, which become very, very relevant in terms of these crisis situations. Also, the level of compliance and the protection that a local regulator has taken on that aspect, that also becomes very, very critical.
Well, let's assume that it was a cyber attack, right? It's not 100% convinced.
Well, yeah. But when it will be, like, what will be the?
Well, I mean, I know the same as you, right? Because I was here, but it's currently under investigation. So.
Well, we'll see what
But
happens.
I would like to add that also, from a corporate point of view, when you work in an organization, there is another point that we should also take into consideration: how to balance privacy with security, right? Because if we start implementing monitoring technologies, to monitor the activities or to protect the assets of the company, right? Threat detection systems, right? That can be a conflict with the data protection laws, right? So we will be aggressively monitoring individuals, right, in conflict with data protection point of view. So there must be always a balance, right? So we understand that companies need to try to protect the assets, but at the same time, we cannot lose the individual rights.
Absolutely. And now that I have you, like, what are some kind of practical benefits that you see of a strong compliance posture when litigation does arise, when things actually go wrong,
I think compliance obviously is the key. It's always a bad idea to look at compliance and trying to fix it when you're in a so to speak crisis situation, or when you're into litigation, because there is not much that you can do at that time. So I think that will probably be my short answer to this.
And like, what do you think are the key challenges that are arising from the compliance to, cybersecurity regulations, where you were talking about PDPL specifically?
Again, I think consent would be probably the one of the main topics that we have already discussed. Another would be perhaps the transfer of data and how what if it is indeed transferred, and there are obviously challenges around it in the jurisdictions that you're operating, not only within the GDPR but also, for example, in Saudi Arabia as well, where a lot of regulators around the world are taking the approach that it has to be stored locally. So there are challenges with that transfer as well. And also in terms of what cybersecurity protocols have you deployed on that. And for corporates, obviously, it's a very difficult and murky world, because you have so many solutions, so many consultants who would say that their solution is the best. So I think the strategy should be to basically obviously start with a very, very good consultant, so that he can find the better solutions. You can say, I don't think there is a best cybersecurity solution in the world at the moment, or even if there is, I think the hackers or people who are working on the wrong side of the technology are perhaps one step ahead of them. But I think in order to look for a better solution, it is very important to have a good consultant, to have consultants who have had a track record of helping the companies, so that you can potentially avoid any of the issues like maybe what happened yesterday, or we saw very recently when Heathrow Airport was shut down for one whole day, and investigations are being carried out. I don't think there's an official statement out yet whether that was a result of a cyber attack as well.
In defense of consultants, I will say that I think that, perfect is the enemy of good. So it's difficult to come up with a perfect solution or a perfect strategy, but you can come pretty close, especially when you come with experience across international organizations, the private sector, government projects. I'm going to be humble here, but honestly, when you originally start seeing things from a only technical perspective, you are like the horses like that you are not able to see around you, and you need to have a comprehensive view and a sense of urgency, because cyber attacks we are already late for the cyber attacks that are happening now. So I think that together, as we mentioned in the previous panel, working in silos is no longer a thing. The cybersecurity department has to work with compliance. It has to work with legal. We have to work together. We have to have a corporate culture of embedding all this in the values of the company and making it as a second nature to be able to comply when things do go wrong and conflicts arise. So we were talking about minimizing litigation risk across jurisdictions. I want to move into the key legal differences and the strategic impact that this has. Right? So what do you think are the most relevant differences among these data protection laws that we've been mentioning that may affect litigation strategy or compliance obligations?
Sure, absolutely. Again, building on to the discussion that we have had so far, every law is, as I said, it has its local nuances. Although I completely agree what was being discussed in the earlier panel as well, that GDPR has been instrumental in so many regulators coming up with their laws. It does draw a lot from that, but there are again some local nuances, some things which are different in every law. So that is one thing. When you talk about differences, the transfer, I think the data transfer regime is probably the point or the topic which would be different in most of the pieces of legislation. Some of the countries or some of the laws are not very protective of data staying. Of course, they're protective of confidentiality of the data, but not for the data staying within the borders. They can be, for example, transferred to whitelisted countries. In Saudi, we saw an example of having very, very strict local data storage requirements earlier. But then once the law came out, they did come out with the SCCs, the standard contractual clauses, or the BCRs, binding common rules, where data could be transferred outside so long as a certain protocol was followed. We keep getting the indications that a whitelist, that a list of countries which will be whitelisted would be coming out quite soon from SADAIA, which is the regulator. Mm-hmm. We have not seen that yet, but it will be probably forthcoming. Earlier, the government data also had to be stored within Saudi Arabia, and that was not only a requirement which was coming from the PDPL, it was a requirement which was coming from the national NCA as well, the National Cybersecurity Authority. We have seen that requirement going away last year, in the second part of the last year. So there is obviously some movement in terms of transfer, but then again, I think that will be one of the main topics. As I said, consent, probably, how much informed that consent is, how much of a positive action would you need from a person to, for example, send them any marketing information. And that, by the way, is also is covered in the draft amendments to the implementing regulations of Saudi as well, the draft which just came out a couple of days ago. Yeah. So all of this is very, very relevant in the field of AI, and how AI technology and how AI solutions are being deployed and developed these days, because obviously your LLMs are being developed on a large part of data. We have seen numerous cases of litigation in the US as to how that data or how those agents are being trained, and we have also seen a shift, so to speak, by the judges and the courts as to how much confidentiality or how much IPRs do the authors have in that work.
That was so comprehensive. Thank you so much. Please, Beatriz, can you give us your...
One thing to add before we move to the AI, which is a huge topic. Something that we should not skip, it's the accountability. Yeah. We sometimes forget, that because I think that we came from old style, on which companies do things because I have an act or a law which states the things that I have to take care, right? So we always use this reactive mode, right? I do things because I have a law, and if I don't comply with the law, I will be fined, right, as a company. And since GDPR came into force, and that's the trend, that's clear, that we don't forget that the laws are proactive. I mean, they want companies to follow up this proactive mode. So don't wait, until I receive the fine, right? That's what accountability. That's why mostly all data protection laws around the world, and not only data protection laws, it's the same as cybersecurity laws, right? We have to demonstrate. We need to document things. There is no any single solution, right? But if companies are able to demonstrate why we take route A instead of route B, that's also part of our legal strategy. Risk mitigation, right? We will need to be able to identify any cyber risk, privacy risk from the beginning at earlier stage, and design a plan to mitigate, not eliminate, because when we are talking about technology, I think it's quite challenged, but at least to demonstrate, right, that we are doing things and we are taking things in a responsible way.
That is a great point, and what we were mentioning before, right, the proactive approach, to not wait until things get wrong to try to mend them, to try to be proactive. And you mentioned one of the key points that were discussed in the previous panel as well, right? The importance to not do it just to avoid fines, to understand that to have a comprehensive compliance strategy would also save your reputation and your resilience, and also the trust. You by doing this, you build trust not only within your organization, but also with your investors. So this gives me a perfect segue to move into AI as well, and emerging legal risks. We were talking about accountability. That's one of the main principles of an ethical use of AI. And AI tools become more embedded into corporate operations. So what legal challenges do you both see that are emerging in areas like commercial contracting, intellectual property rights? What are the differences among these PDPL, GDPR, data protection laws that may affect litigation strategies or compliance obligations, where we're talking about this emerging technology that affects everyone?
Well, I can start from a corporate point of view. I don't think the AI, shall be treated in an isolated way. As is, I think that AI as privacy has several common elements, Of course, there are specific requirements when we are talking about AI models, but the foundation could be the same. So, if you have a data protection privacy framework in place in your companies, there are common elements that it can bring into the AI governance. From a corporate point of view, I think that right now that AI is there and we cannot avoid it, you said, I think that companies should have a strong protocols or policies, not forbidden, because that's not practical anymore. Just like a joke, we started forbidding the use of ChatGPT to all employees, but it's impractical. Everybody was using their own private accounts instead of the corporate accounts, so at the end, the information was in ChatGPT, right? So what we are doing, I can give you an example. We have our own generative AI at corporate level. It's in a strong and our cloud environment, so everybody can use it. If we go through third parties AI models, the extraction is very clear. No trade secrets, no confidential information, no personal data.
And I think that reminds me of a question that was raised yesterday regarding the use of this generative AI models in our profession, right? Whatever, we're in corporate, we're a small law firm, whatever we're doing, and what kind of information we feed the model, right? We were hearing yesterday of the use of AI models. I suppose they were talking about ChatGPT or models of the sort, it doesn't matter, to summarize contracts, let's say. Does your client know that you are feeding an AI model that you have no idea where that information is going to, what's going to happen with it, and where it's stored, and what happens if there is a data breach? That you are feeding it that sensitive information of our contract, that it's very private and it now thinking out loud, it brings me to the concept of confidentiality that was also very much discussed yesterday. So I am very well aware of the importance in the effectiveness of our work, of everyone's job in using these tools and feeding the models with something that will perhaps take us hours to dissect. But let's think about the information that we're giving. Why are we trusting these models as much? Why?
Well, I don't. Personally, I don't.
What your company is doing, I think it's a best practice that we can actually highlight in this conversation. Not because, you know what, it's a solution. Because in cybersecurity, we always try to work with trusted vendors, trusted partners. We don't use a PDF converter randomly from the internet. If an employee does that, there will be an alert that will go to the cybersecurity department, and we will make sure that that is corrected and that there is a culture in cybersecurity awareness to avoid using this kind of things. Because what are you uploading to this random website that we don't even know who owns it? Perhaps you were just innocently converting a Word document to a PDF. But that information shouldn't be there in the first place. Same thing happens with ChatGPT. And I think that what your company is doing is pretty commendable because it's a solution. But again, it comes with culture and awareness because, as you said, employees are still using their personal accounts to access these models.
I mean, I think the cultural and training awareness, I think it's important. I mean, when I said that I don't trust on this kind of AI models, I mean, I think it's it's a new way of working. For me, it's not the final result. I don't trust 100% on what these AI models are saying. I think there is a lot of work behind, but it's a good point of starter. I mean, if you have to do a presentation, I mean, it's good because they can give it to you some ideas, right? So I'm not saying that we should not be using it. It's something that it's there.
Absolutely not.
But
no, absolutely
it's, for me, it's a mean. I think that there is a lot of work behind using these AI models. We need to train our employees, right, about the information that they can upload it or not, or share with AI models. And something that it's also important, it's the third-party contracts. I mean, these AI model systems, who is reviewing the terms and conditions? Who knows about the privacy policies under ChatGPT or any other?
No one's reading
that.
No
one is reading it, right? So at the end, we are giving freely, all materials to train their AI model, and no one is monitoring or see what is the wording, right?
Yeah. Anum, in your practice, what challenges do you see, right, in terms of emerging in commercial, in IP? What can you tell us about that?
Well, I think the most important challenge would be the IPRs and a review of the contract. So especially when a company is working on a contract which has an AI element, then an AI addendum of 1 page or 2 pages is not going to work. You will have to do, or somebody will have to do a root and branch review, proper review of the document, because again, as has just been mentioned, you need to see where your data is going. You need to see the AI solution that is being used or being deployed by your vendor. If there are any intellectual property concerns there, and how and confidentiality, of course, of the data needs to be protected as has just been mentioned. But then, in terms of ChatGPT, I heard the phrase 3 to 4 times. I think AI is now at a stage where us as individuals or companies cannot compete with it. They have to collaborate. They have to make use of it. And in any case, I think in our daily lives even, we are, it's integrated, it's inbuilt into so many devices that we are using that we are not even realizing. And by the way, I have a very interesting statistic in terms of adoption of AI as well. I would like to get you guys involved as well. I'll give you one statistic, and then I'll ask you a question. Sorry, no prizes for the right guesses. But so mobile phone now everyone uses a mobile phone, right? Most of us use it. How long do you think it took? For a side, I'll give you a statistic. So it took 16 years for the mobile phone usage to reach 100 million users. Okay, 16 years. After that, I think one of the biggest pieces of technology that has been adopted by a lot of users is internet, right? How many years do you think it took 100 million users to start using internet? It's less than 16 years, I'll tell you that. 2-3 years. Anybody else? All right, it took 7 years. 7 years for 100 million users to adopt or use internet. Facebook. Next big thing you can say. No, 100 million users, how many years?
1 year.
1 year, okay. 3 years. So mobile phone, we're talking about, so we are talking about maybe technology advancement or development since the 90s, right? So mobile phones, 16 years. Use of internet to be adopted by 100 million users, 7 years. Facebook, 3 years. ChatGPT, any guesses? 1 year? 3 months.
3 months, yeah.
3
But that
months.
has many elements. That's many elements. Like it keeps building upon, like internet was like the building blocks, and it was very expensive at the beginning, and then
Exactly. So AI, as I said, is perhaps even an augmentation of some of the technologies that we had before, right? So as has just been mentioned. But in terms of adoption, everybody has adopted it, maybe sometimes even without realizing it. So the companies have to collaborate. The companies have to work with it. It's again in terms of who are they using, what data are they giving, what confidentiality do they have onto that data, whether it is a private network, whether it is a network given by or a solution provided by Microsoft, for example. Their Copilot product is very popular these days. It all depends, but then again, it all brings us back to some of the concerns of IPR, intellectual property rights, as to how those large language models are being trained. What data are they being trained on, sorry. And that is why, as I said, we have seen a lot of litigation in the UK, in the US, mainly against Microsoft even. And we are yet to see, but again, we have not seen any judgments coming out of the courts stopping it, because they also realize that we have to work with this technology, we have to move on with this technology, we have to do it within reasonable parameters and obviously in a compliant way, but you can't stop it.
And that's because I think that 1 year ago, or less than 1 year ago, Europe tried to stop and blocked ChatGPT, and it was in the European Tribunal Court, and they didn't. Yeah.
Yeah, and I think that as they're being used more, these generative AI models, governance mechanisms and contractor clauses will have to be in place in order to have this proactive approach to avoid issues, internal issues with these AI tools, and also to mitigate third-party risks, right? I think that we have some time for a couple of questions from the audience. If you want to raise your hand and kindly keep the questions concise, because we're a little bit tight with time, but we would like to keep this conversation going. We have two great experts here, and so who would like to come up first? Right here.
Thank you very much, Beatriz and Mohammed. Favorite hot topic of
You are going to ask me about the GDPR.
No. I want to address another, elephant in the room. Like, we know with the rise of deepfake technology, the malware and the phishing emails that are so pervasive, and the deepfake technology is so accurate and perfect in its essence, it's very hard to distinguish between what is original, what is not, at least from a naked eye, unless it is being run through forensics. My question to you as legal professionals is, what do you, then recommend, or if a company is your client, what do you recommend to them, as Betania also recommended, that you should have a proactive approach? That is, you need to take steps before anything happens. What do you recommend? Because, Heathrow and Marriott and all these big giant, even Facebook was not spared from hackers. How can companies, without investing in millions of dollars in proprietary software to put up walls, and they can't disclaim like this, like we won't be liable, if their clients are reposing their sensitive information to them, how do they handle liability issue in the contract? What do they say? Aside from that, yes, we have security measures, because there is no ceiling to it. They will always turn around and say, no, it wasn't enough. What do you then advise your clients regarding how to avoid liability regarding this? Thank you.
I can give you my approach from a corporate point of view, because what you had said, it's quite interesting. I'm not advising my customers. I mean, I'm an internal role, but the first thing, cyber attacks are more sophisticated than ever in the past. We always conduct trainings because we have the policies, we have the protocols. We train on our employees because, well, phishing is there, and it's constantly happening, right? And well, it's in your day-by-day basis, and you don't realize, or you are not really focused on the URL, right? And you click on, and that's it. Yeah, the problem is there. Also, we have a cyber liability insurance in order to protect the company. And this is a trend that even in the past we have not seen that many customers were requiring us to have this cyber liability insurance, right now in tenders, wherever you are, I'm not talking about any particular country. So also customers are requiring us as a provider, an IT provider, to give them some kind of guarantees in order to protect their own assets.
Any other questions? Well, thank you so much for this truly enlightening conversation. Thank you for the audience for your attention. I've seen that you've been very engaged, and I don't blame you. This is a fascinating topic, and it's not something that we are always talking about. We are sometimes very concentrated and focused in our own practice, in our own, in our own silo, and cybersecurity is there, data privacy is there. It is important. It is something that, again, we should be working together. We should be having a comprehensive approach. It is important for our compliance. It will continue to evolve, and it's a must in our legal strategy. So thank you so much. Please enjoy the rest of the conference. You're done with me. This is my last panel.
Thank you. Now I request the moderator to honour our panellists. Thank you, everybody. Now, if we take a short 5-minute break, have some coffee, have some more cake, and then we'll come back at 11:15. Thank you.